Cambridge Open Access, una iniciativa de la editorial de la Universidad de Cambridge, sirve a los autores, las bibliotecas y la comunidad académica a través de la publicación de contenido de acceso abierto de alta calidad y revisado por pares para que los lectores puedan redistribuir, reusar y adaptar el contenido en nuevas formas. Nuestras iniciativas permiten que los autores cumplan con los mandatos institucionales, publicando en acceso abierto bajo modelos sostenibles. A través de nuestras iniciativas de Read and Publish, hemos logrado que más de 900 instituciones alrededor del planeta puedan publicar sus artículos y libros en acceso abierto. Y estamos trabajando para sumar más instituciones en diversas regiones geográficas a iniciativas como Read and Publish, Open Engage y nuestras políticas de archivo verde. Deseamos acelerar la capacidad de la investigación académica para resolver problemas complejos y beneficiar a la sociedad. Esperamos que pueda unirse a nosotros en esta iniciativa. Descubra más en cambridge.org/Open Research.
Hola, muy buenos días, estimados asociados. Pues estamos nuevamente en este webinario, casi ya para terminar octubre, pues muy emocionados porque aquí nuestra empresa amiga Cambridge University ha traído un tema que es muy importante en este momento, que tiene que ver con la ciberseguridad y sobre todo todos estos aspectos que los bibliotecarios deberíamos de empezar a conocer ya al manejarnos en ambientes digitales donde sabemos que la seguridad de la información pues tiene que ser resguardada de igual manera que lo hemos hecho en la parte física, en las bibliotecas y centros de información. Pues justamente el tema de hoy que les traemos y con el cual empezamos esta semana es la privacidad de los datos personales de los usuarios de bibliotecas y centros de información. Para ello, nuestra empresa amiga Cambridge ha invitado a un excelente ponente, que es el doctor Ari Waldman, que lo va a presentar más adelante, nuestro excelente moderador, que también nos acompaña el día de hoy, que es Ariel Morán, a quien ya en otras ocasiones nos ha estado con nosotros. Quiero comentarles que Ariel Morán, pues es doctor y también, disculpen un momento, es el doctor Ariel Moral es docente del Colegio de Bibliotecología y Archivología de la Facultad de Filosofía y Letras de la UNAM y también es un experto en estas áreas. Quiero decirles, bueno, que Cambridge University Readers, como ustedes lo han visto ahora en el video que nos han compartido ellos, pues es una editorial académica que nos ha acompañado en todo este año y que, bueno, es una de las más antiguas en el mundo. Tiene un departamento, primero inició como un departamento en la Universidad de Cambridge y ahora es una organización sin fines de lucro cuya misión consiste en desarrollar el potencial de las personas con las mejores soluciones de investigación y aprendizaje. Publican libros académicos y revistas arbitradas bajo los más rigurosos estándares internacionales y proporcionan contenido a universidades e investigadores alrededor del mundo. Además, Cambridge University Press cuenta con diversas iniciativas en favor del acceso abierto y el conocimiento libre, entre ellas una de las más importantes, mecanismos como el Read and Publish, cuya política es compartir en redes sociales y en la plataforma de Open Engage, la cual permite a cualquier persona subir investigaciones para que sean comentadas por sus colegas. Sin duda alguna, una gran iniciativa. Sus plataformas abarcan una gran variedad de disciplinas, tanto en humanidades y ciencias sociales, y también en ciencias naturales. Está disponible para instituciones y bibliotecas en todos los ámbitos. Cambridge Court alberga todo el contenido de monografías y revistas académicas, mientras que la plataforma de Higher Education, lanzada en el 2020, cuenta con más de 790 libros de texto para la enseñanza universitaria avanzada. Pues por todas esas iniciativas y por traernos a este excelente panelista, pues les damos las gracias a nuestra empresa amiga y le cedo la palabra a nuestro moderador, el doctor Ariel Moral, para que nos presente al ponente y conduzca esta sesión. Por favor, doctor, si gusta tomar la palabra.
Gracias, doctora Vega. Hola, muy buenos días a todos los miembros del AMBAC, a los estudiantes y a todas las personas que nos siguen en otras latitudes en América Latina y en España. Como parte de los webinarios que está organizando la AMBAC en este 2021, que comenzaron en febrero, el penúltimo de este mes, que es el que concierne al día de hoy, y en el conteo general de todos los webinarios del año, y si me equivoco, me corrigen, esta es la sesión número 74. El webinario de hoy se intitula La privacidad de los datos personales de los usuarios de bibliotecas y centros de información a cargo del doctor Ari Ezra Waltman, quien es profesor y director del Centro de Derecho, Información y Creatividad de la Universidad del Nordeste en Boston, Massachusetts. Antes de cederle la palabra a nuestro expositor, hablemos un poco de él para que lo conozcan. El profesor Waltman se formó a nivel licenciatura en la Universidad de Harvard, primero como historiador en Harvard College y luego en la Universidad de Leyes como abogado. A nivel posgrado realizó una maestría y un doctorado en sociología en la Universidad de Columbia y sus líneas de investigación actuales se enfocan en el estudio sobre la legislación y las aplicaciones tecnológicas, pero específicamente sobre las relaciones de poder asimétricas que surgen y se fomentan y se consolidan al cobijo de las leyes y la tecnología, con especial interés en temas como la privacidad, el acoso en línea, la libertad de expresión y la comunidad LGBTQ. No? Hello, good day, Professor Waltman. Thank you for your time to give a talk in this forum of the Mexican Association of Librarians. I'm back for its acronym in Spanish. I am going to moderate the webinar. Okay, Professor, you can start with your exposition.
Buenos dias. Thank you very much. I appreciate being invited to speak with you all. I'm going to conduct this talk in English, but it's a pleasure to be here. I appreciate and welcome the opportunity to talk about this research. So I'm going to share my screen just so everyone has a, you don't always have to look at me while I'm talking. Here we go. All right, so I'm going to talk for a little while about some of the research that I've been conducting over the last 4 years, where I've had the opportunity to be inside technology companies, observing how they do their work, talking to current and former employees, talking to product managers, programmers, designers, the people who code products, lawyers, privacy professionals. And this project is not about what companies of all sizes say that they do about how they protect their privacy. This project, because we all know what they say they do, like they constantly tell us that our privacy is important to them. Every email that we receive, whatever language, always starts with your privacy is important to us, or that your privacy is important to us, or we're committed to protecting your privacy, to give you control over your choices. Or continuing on that line, saying that your privacy should be your decision, or more control over something that is very important. These are the things that companies say they do with respect to our privacy. But what do they really do? Like, what is behind the curtain? What is behind the screen, behind all of the marketing that these companies do about how important privacy is to them? We are hearing right now from whistleblowers. We've heard from whistleblowers for years, but one in particular, Frances Haugen, who testified before the US Senate and now is testifying before British Parliament. She understands, she is blowing the whistle. We call a whistleblower someone who recognizes what is something is going wrong inside the company and wants to be honest and open about it. But the main thing that I found is that most people don't think what's going on inside these companies is wrong. They're blowing the whistle without actually knowing that they're blowing the whistle. So I'll start with my argument. What I have learned is that technology companies of all sizes, what they do is they take in people, they take in law, and they take in words, and they leverage the coercive capacities of their organizations, their hierarchies, their reporting structures, the organizations and the rules that they impose on their employees to normalize a data extractive business model. They normalize thinking and talking about privacy in ways that are weak. They normalize turning legal protections into just box checking, and they normalize the process of designing new technologies in ways that ignore privacy. they use these structures to co-opt privacy law and privacy professionals, even those people that consider themselves privacy advocates, or even those people who come into their work thinking that they are privacy advocates and earnestly wanting to do better or push their organizations to do better. It doesn't work out because those people exist within an organizational structure that co-opts them. And it habituates them over time. It makes them accustomed to acting and practicing their work in ways that make it seem like they're protecting privacy, but in fact, they're doing the exact opposite. So what I've learned from this research is that we can pass all the laws that we want. We can talk about privacy, and we can think we care about privacy, but as soon as that work gets inside a tech company, it's being co-opted, and the law allows that, especially the law in the United States, the law in Europe as well. Laws across the world allow privacy law and privacy professionals and designers of data extractive products to be co-opted into this grand goal of extracting data for profit by capital and leaving us on the receiving end. So we are part of this process. We facilitate our own subjugation. Privacy professionals, even those that consider themselves advocates, are complicit. They become habituated into performing their work in a way, as I said, that seems privacy protective but isn't. And the law is not only insufficient, but it allows it. My goal here in writing this book is, and depending upon what audience I'm speaking of, when I'm speaking in front of privacy professionals, I say that my goal here is nothing less than coming for your jobs and for entirely redesigning the profession. For people who care about privacy on the outside of for-profit technology companies like librarians, my goal here is to bring us all together, bring, in this case, individuals, not groups of people who care about their own privacy, care about the privacy of the people that they care for, into a social movement to change the way informational capitalism works. So first, I want to talk a little bit about methods, about how I came to this research and how I came to this work. Getting access to these professionals and these companies is quite hard, as you can imagine. They're concerned about being seen negatively in the press or in any kind of book, no matter how many people read it, even if it's an academic book where only a few people actually read the book. But in many cases, there were companies like, for example, Google said that we can't give you an official visit to see our company, even if I was going to sign a confidentiality agreement. You can only speak to us on deep background and never quote anything that we say. Facebook wanted pre-approval of quotes that I would use in my work. And other researchers have accepted those terms, but I thought that those violated my research ethics. So the way to go about doing this kind of research is you have to improvise. Sometimes it's a matter of talking to current and former employees at conferences. Sometimes it's reaching out through your own networks and doing what social scientists call snowball sampling, to go from one contact to the next to the next. And sometimes it's a matter of those contacts finding a company or finding someone who is willing to give you access. And that happened with three different companies, three different medium-sized technology companies, where I was allowed, after signing confidentiality agreements, to sit in on their meetings, see how they do their work, interview privacy professionals and designers. And then, of course, also what we call interface ethnography, which is a lot of these companies have these closed door meetings where they invite professionals and experts to hear about what they're doing, about the new things that they're doing. As I said earlier about whistleblowers, right? Whistleblowers that we know about know that what's going on is wrong, and they want to share and they want to be honest. In so many occasions that I found during this research, a lot of these people don't think what's going on is wrong and they're willing to share. But what they think is actually what they're sharing is actually blowing the whistle on a crusade against privacy inside these companies. So I highlighted three areas where these companies undermine our privacy. The first is discourse. And what they do is one of the ways that they conscript their own employees into doing anti-privacy work, again, even if they consider themselves privacy advocates, is to get them thinking about and doing privacy and practicing privacy in terms of, by way of a definition, or thinking about privacy in ways that are corporate friendly. So we might think that that an idea, thinking about privacy as control over your information, is liberatory, right? How can anyone talk negatively about having control over your information? But this is exactly the kind of definition that these companies want, because as soon as you click agree, and as soon as you toggle that button on your iPhone, you've given up control. And in fact, many of these companies that I've spoken to, and many of these companies that I observed, and employees that I've interviewed, they made arguments in court, in litigation, both in the European Union and the United States, saying that once you share something, there's no longer any privacy. There's no longer any privacy protection. So privacy as control is not liberatory. Privacy as control is exactly the kind of idea that privacy that companies want us to think. And they ingratiate this idea inside their companies, throughout their organizations. And there are many ways they do this, and I talk about them throughout the book. One way is, as you see in a lot of the emails that you may receive from these companies, is they just say privacy is important. And then they'll add, as you saw at the beginning of this presentation, add things, well, privacy is important, we're giving you control. And there's a lot of psychological evidence that shows that the repetition of this information, repetition of these words, starts to make us think about privacy in terms of control. And they do that for their workers as well. So if you are, imagine you are a chief privacy officer or an executive, and you have to hire a privacy team because a law or a consent decree from the Federal Trade Commission in the United States or the General Data Protection Regulation in Europe said you had to. Well, one way you can get all these workers on board is to give your privacy professionals assignments that have only one definition of privacy. So you have companies that have large privacy departments, many of where I interviewed employees, and they brag about the work that they're doing. And they say, I have so much work, I'm doing so much work, and of course I'm having an impact. But all of their work is about more transparency. All of their work is about making privacy policies longer. All of their work is about how choice is the way to go to protect privacy. But as I said, choice is not an effective or liberatory way of protecting privacy. How many websites do you visit every day? How many apps do you have on your phone? Is each individual one of us capable of managing our privacy, every toggle, every button, every cookie consent on every website that we visit every single day of every year? No, but that's exactly what these companies want, because they don't want us to manage our privacy. And an interesting story that happened when I was interviewing a general counsel and his team at a mid-sized technology company in the United States was that they said to me in an interview that people who share information on their platform still retain privacy rights in the material that they set. And they were very honest about that. They even say that in public-facing PR, public relations and communications and press releases and quotes on TV. But then I showed them, then I showed the general counsel, well, if you believe that, then why, and I showed him the brief, then why did you make this argument in a case in California that says the exact opposite, that you believe that people who disclose any information on your platform don't have any privacy rights in that information? And then he stormed out of the room. And this wasn't unusual. There are a lot of people who, being called out on some of their lies, would walk out of the room or just get defensive. But after calming down, or another one of his colleagues said, well, that's just because we are committed to zealously advocating for our client. And the zealous advocacy canon is something that lawyers learn, when you go to law school, that your client enjoys or deserves your best. So these people had justified their lies and their arguments against privacy through what they saw as professional ethics. Again, professional ethics are not in themselves anti-privacy, but you can see when filtered through the organizational structures of these companies that it turns out to being anti-privacy work. So having undermined how their employees think about privacy, they set about to undermine the law of privacy and turn it into checkbox compliance, which means that we can pass all the laws that we want, but if companies are going to gain control of it, if we rely on companies themselves to conduct their own, to be integral pieces in ongoing monitoring, they're just going to turn it into box checking. right? And I saw this quite a bit. You had people, privacy professionals, who defined their work based on how much they defined their impact, based on how much they were doing, as opposed to pinpointing a way in which the technologies that their companies were creating were in somehow more privacy protective. So I had a lot of privacy professionals who said things like, we are busier than ever. Of course we're changing things, but could not point to a single thing single change in or pro privacy protections in products other than, well, we have longer privacy policies or more detailed privacy policies. Companies also minimize what the privacy office can do, hobbling their privacy office. By some of the companies that I observed, they split their privacy budgets between the IT department, the law department, and the compliance department. Again, that in and of itself is not anti-privacy, but when a privacy professional needs something done, then she has to fight for money between 3 different groups. Another way to hobble the privacy office is to just minimize what they do. So there are several big companies where the privacy office is not at all responsible for compliance with privacy law. They're just responsible for getting vendors to automate compliance. Another way that they undermine or make it hard for privacy professionals and privacy lawyers to give active privacy advice is they make their role very precarious. So I had several lawyers who kept saying, well, I don't want to be the one saying no all the time. I can't be the one stopping progress at this company. I can't be the one that's preventing innovation. So what they do is, because of the ethos of the company, because they don't want to lose access to the chairman or to the president, they moderate their advice and they let most things go through, or they moderate what the company has to do in order to comply with privacy law, which is check boxes. I even saw a privacy impact assessment, which is a document that you have to fill out pursuant to the GDPR, as required by the GDPR and Federal Trade Commission consent decrees, which essentially is supposed to assess the impact, the privacy impact, the data extractive impact on users. So I saw one of these forms, which was turned into a chart, laminated on an engineer's desk. And all they had to do was these little boxes, and all they were doing were just checking. And in fact, not just were they checking, but on the laminated piece of paper, it said, just check yes here. And it pointed to the yes column. So when I asked the chief privacy officer of that company, well, how is this compliance with law if you're just telling them to check yes? They blame the engineers, and they said, well, engineers can't understand this stuff, so we have to make it as simple as possible. So again, complaining that engineers can't understand law itself is not anti-privacy, but running through this system, running through this structure, it undermines the work, the extent of privacy law and the way privacy law can protect us. And finally, with these companies completely unmoored and unbound by privacy law and privacy discourse, they design technologies that extract data from us, and they do so. They even do more. They ensure that privacy can't gain a foothold in the design process through other tactics in their organizational structures. So, for example, they assign small design or small coding responsibilities to small teams. That's how a lot of companies work. It's very efficient, right? You have a small team, they're focusing on one engineering problem, and then you put it all together in a big product. That's why you have product managers. But what a lot of companies do is they keep each team ignorant, right? So not only do they foster kind of turf wars, it's like, well, this is my responsibility, this is the job I was given. It's that they don't tell people that someone else is working on privacy. So they just are left to assume, oh, someone else must be doing that work, when someone else really is not. Companies use their engineers put their engineers in privacy meetings to turn privacy into just what can be coded, which again turns privacy into either a checkbox or a toggle button or something that's easily designed, as opposed to what privacy is, which is really establishing or responding to people's expectations and maintaining confidentiality and trust of your users. Another way companies do this is in response to privacy scandals or privacy violations, which I'll define as something about data misuse, right? Not unauthorized access to data, but using data in a way that is offensive to our expectations. So the Cambridge Analytica scandal, comes to mind. That wasn't a data breach. That was a privacy issue because people had legitimate access to the information. They were just using it in a way that was unexpected and harmful. So what a lot of companies do is in order to codify or make it codable, turn privacy into something that is just codable, they task engineers with giving security responses, like preventing breaches to privacy problems, which enhances this idea that privacy is something that can be coded when only a small part of it can be coded. And all of these things, another tactic that I saw companies do is that when they're doing the designing, engineers are the ones that see the privacy issues as they come up, as they're designing a login screen, or as they're designing buttons, or as they're designing, dark patterns on the screen to collect data. And so they're the ones that are dealing with it, see it all the time. One way to enhance privacy work in these companies would be to have a close relationship between engineering teams and people whose job it is to spot privacy problems if they were allowed to. But in fact, what a lot of companies do is they separate them. They don't allow lawyers or privacy professionals to actively, affirmatively work with their design teams. They require design teams to report problems up the ladder and then report it to a lawyer or privacy professional, which with that process, you can imagine 95% of the privacy-related coding issues, the privacy-related design issues get handled ad hoc because you're not going through that whole process, or often it just ends with the design team manager or the design team product manager, never ever getting to someone who's actually trained in privacy. So again, hierarchies and reporting structures, they're not themselves anti-privacy, but you put all of these things together, and what you have is this development of this false consciousness. You have the development of this idea among employees of all sorts that we're doing a lot of work, and that's just how it's done. This is what we do. This is what privacy law is, and I'm a part of it. I'm doing a lot of work. I'm just doing the thing that's assigned to me. It's not my problem, or it's not my fault. Or I'm the privacy expert, but I can't talk to these people who are doing their work. Everyone in this process has become habituated to doing the work in a certain way, constrained by structures inside companies, that this is what they think privacy law is. This is what they think privacy is. It's making things easier for engineers to just check boxes. It's moderating your advice so you don't lose access or don't lose your job. It's deciding that you're going to respond to privacy problems with security fixes. It's saying one thing in a privacy policy, but making the entire opposite argument in a brief. Like that, you would imagine, would cause some cognitive dissonance, some inability to reconcile these two diametrically opposed views, but it doesn't, because everyone has just been inured, just been habituated to behaving and practicing in this way. So why is it that all privacy laws these days, the GDPR, the proposals for comprehensive privacy legislation in the United States, privacy law in South Africa, privacy law in Israel and other countries, why is it that they all roughly look the same? Well, because the law has been endogenously created. The law comes up from the bottom. It is influenced by what companies want. And what companies want and what companies have been doing is they've been habituating us into thinking that privacy law is just this. Privacy is control. Privacy is just checkbox compliance. And privacy is about designing in more toggle buttons. And that's it, right? And that is the result of this concerted campaign to undermine and to co-opt both the law and people involved. So I'll end with so what can we do about it, right? What do in particular librarians do about this problem? Well, I think there are a couple of things that I think we can all do. And one part of it is we need to build a social movement, right? Changes to how the system works don't happen from the top. They happen from active, engaging, worker-inspired, individual-inspired social movements to undermine our own subjugation, to liberate ourselves from our own subjugation under informational capitalism. And librarians don't face the same incentives. You don't have to use Google for data analytics as for-profit companies feel that they do. You can learn about, you can teach from very early ages. When young people come into libraries, we can have better media literacy, better understanding about how companies are subjugating us. We can have, we can engage and use the work that librarians have been doing for a long time when it comes to free speech, when it comes to information access, technology access. We can, librarians can be a source of engagement, centers where people can come to escape the kind of all-encompassing data extractive capitalism that that exists outside. And if there becomes some way to galvanize popular movements, librarians can be a part of that. Privacy is not just about control over data. Privacy is about civil rights. Privacy is about non-discrimination. Privacy is about sexual liberation. Privacy is about social welfare, right? The ability for individuals, no matter what your socioeconomic status, to gain access to opportunities. And the people among us, the people who have access to sharing information and teaching us, play an integral role in building those social movements. Happy to answer questions that people have.
Professor, thank you for exposing us the idea of privacy as a social structure governing information sharing. The usual idea of privacy is control, put an armor plated to the information, supposedly to guarantee autonomy from society. Now we move on to the question and answer section. Agradecemos al profesor Waltman por exponernos la idea de privacidad como una estructura social pues, que rige el intercambio de información. Esto es muy clarificador para nuestro enfoque, pues la idea habitual de privacidad es poner un blindaje a la información para garantizar supuestamente la autonomía de los miembros de una sociedad. Y ya tenemos en el chat de Zoom algunas preguntas para nuestro expositor. En ese momento la audiencia es de 40 personas en Zoom y 34 en YouTube. Tenemos ya una pregunta, tenemos traducción simultánea. A ver, la primera pregunta para el expositor Gary Waltman es ¿cómo percibe los derechos ARCO? Que en este caso ARCO es acceso, rectificación, cancelación u oposición sobre el tratamiento de los datos. ¿Cómo percibe estos derechos y si realmente están operando para proteger a los usuarios de las redes?
So my translation is not working. So could you restate the question in English so I can respond? As best you can.
Okay. Okay. A ver, rights, ARCO is access, rectification. A ver,
quizá nos pueda ayudar la traductora, Ariel, ¿cómo ves?
Sí, pero creo que tiene problemas con la traducción.
Sí, si gustan,
no...
puedo replantear la pregunta en
sí,
inglés.
Por favor.
Ariel, ¿podrías repetir la pregunta en español para traducirla directamente?
Sí, sí, porque el problema aquí es que no sé si los derechos ARCO como tal tienen otra modalidad en inglés, pero es ¿cómo percibe los derechos ARCO, que serían acceso, rectificación, cancelación y oposición? ¿Cómo percibe estos derechos y si realmente están operando para proteger a los usuarios de las redes?
Okay, so the question is, how do you perceive the ARCO rights, which is access with rectification, opposition, and I think I'm missing one, but how do you perceive them in terms of they being able to work to protect users of social media, and if they are effectively protecting users of social media?
Good question. So I did hear ARCO rights in the Spanish version of that, so I figured it was about that, but I appreciate the translation. So rights of access, correction, and so forth, deletion, they're all fine. But the problem is that they're all individual rights, right? These are all rights that an individual has to take agency, has to take the affirmative step to access, right? To click a button to do something about it. But privacy is not something that we're going to achieve when we do it individually on our own. And in fact, that's exactly what companies want, because they rely on the fact that we can't handle all of these consents, all of these access rights, all of these restriction rights, because you have to do it website by website, company by company, app by app, right? They rely on our inertia. They rely on our inability to handle all of this. It's almost, I would think of it in the same way as climate change. Big polluters want us to think that climate change is a matter of personal responsibility. Recycle that plastic bottle or compost that food. But the only way we're going to solve our climate change, or solve our impending climate disaster, is international cooperation at the systemic level, less flying in less flying in planes that give off so much emissions, right? There's going to be systemic things, not individual things like recycling. So it's fine, but it not only does it not achieve what we want, but it keeps us thinking that privacy is a matter of individual responsibility and individual rights, when it's not. Privacy is a social issue. It is a social problem. And in fact, how can rights of access, rights of correction protect us when things like when we go online and companies are collecting data on us? They're not collecting data on individual people. They're collecting data about us generally, right? That we speak a certain language, that we have a certain color hair, that we buy certain types of food, that we live in a certain place. Those things, those pieces of information are used to manipulate other people. Also, when we participate in things like DNA testing online, like 23andMe, those companies, which I'm sure you've heard of, you can consent to that, but you can't consent on behalf of all those people that share your DNA, right? So the information industry and informational capitalism are social in the sense that there is no such thing as individual consent to data collection, because all data collection implicates other people. So individual rights are never going to be appropriate to protect privacy.
Issues no matter. Yes. Yo tengo una pregunta en lo que los demás se animan. Professor Waldman, I have a question. Librarians work, among other things, to organize information so that it is shared, which is why we connect with the knowledge production process. In this sense, how important can the librarian be in the institutionalized community governance of the sharing and creation of information?
Really good question. Well, I think librarians are integral in the process of information collection and sharing. In some ways, one of the things that Google has tried to do is to eliminate the librarian, right? Google's push over the last 20 years, almost 20 years, have been to monopolize knowledge and to make knowledge a matter of code. But on the other hand, there is a pushback through something like Wikipedia, right? Wikipedia is at least a crowdsourced form of knowledge, but imperfect, which is one of the reasons why librarians maintain and not just have a role, but have an important role at a particular inflection point. Librarians have a role to play in stopping the spread of misinformation. Not alone, of course. I mean, you need help from legislation and from governments who actually care about it, democratic governments, and not populist right-wing governments that feed and benefit from misinformation. So you're part of a larger structure. Librarians are part of a larger structure to push back on things like misinformation, to push back on the idea that knowledge is something that is just a Google search away. Or that everything about us is something that can be quantified into ones and zeros and code. So one of the things that some libraries in the United States have done is they've become partners with Google and other social networks in certain ways to allow more access to Google's form of information. But at the same time, they do so and they compromise their users' privacy by using Google Docs or Google Drive, or using the tools of like Google Classroom, which is a data collection machine, such that, so much so that they had to be sued by librarians and the Library Association of the United States, as well as schools. So there needs to be I'm not saying Google is no help in this world. Obviously, we live in the world, but there needs to be a engaged social movement from the ground up to establish like what knowledge is, how can we push back against misinformation that is spread violently through social media like Facebook and Google. And I think librarians play an important role there.
Ok. Le he preguntado, ya está empezando a llegar más preguntas. Le he preguntado, pues, que los bibliotecarios trabajamos, entre otras cosas, en organizar la información para que ésta sea compartida, digo, en términos generales. Entonces, a través del proceso de intercambio de información, de alguna manera nos conectamos con el proceso de producción de conocimiento, que es algo que estudia Ari Waldman. Y en este sentido, pues, ¿qué importancia puede tener el bibliotecario en lo que él denomina gobernanza comunitaria institucionalizada del intercambio y creación de la información? Tenemos ya una pregunta también de Tomás Bocanegra. Ari, what aspects of the law should librarians now to guide our users in matters of personal data protection when they request information that involves personal data or data that may be sensitive?
That's a good question. So I think privacy law sets a floor, sets a lower boundary, right? If someone wants access to personal information, there are steps that people have to go through as a result of the GDPR, meaning that you have to keep, there has to be a reason why you collected it in the first place, or there have to be records kept about access, right? Those kind of things, those are the floor. But some people will say that it's just easy, as long as the information is anonymized, it's no problem, right? These are aggregate or large scale anonymized pieces of information that you use for analytical purposes. Though that's something that is allowed under the law, but is certainly risky because it's very easy for people to re-identify. There are not just isolated stories, but tons of stories where people have gone to public libraries or public access to information points, and they have gathered information, bought something from a data broker, which are these multi-gazillion-dollar companies that you've never heard of what all they do is just gather information from the internet and use the information that they collect in order to harass, stalk, murder, rape victims. So these aren't isolated incidents, right? The data broker industry and the data collection industry is complicit in harm when all you need is information about where your ex-girlfriend is, your ex-boyfriend is, even if there's an order of protection. So what do you do when someone wants personal information? Well, you have the opportunity to say no. You can go over and beyond, over and above the baseline international rules and limit what people can access, whether that's limiting access to what you define as sensitive information, or saying that our tools are not going to be used for this purpose. So if these things vary from locality to locality, at least in the United States. So I'm happy to talk about a more specific example about what kind of personal information that you're concerned about. But in the United States, when someone just wants to go online to get information and personal information about someone, they're more likely going to be able to do it, and they're more likely going to be able to re-identify that person, even if it's unidentified information, because we have out there addresses where we used to live. We have so much information about us out there already. So there needs to be bulwarks against that process. And I don't think we should allow our systems to be used for those kind of purposes.
Okay, thank you, Ari. Parece que no tenemos más preguntas, doctora Vega, en YouTube ni en Zoom. Ah,
Así es, Ariel, no tenemos más
no
preguntas.
tenemos más preguntas.
Okay.
Bueno,
Well, thank you very much for having me. It's been a pleasure speaking with you. If you have any questions, you can always find me on Twitter at Ari Ezra Waldman, or my email is publicly available on the Northeastern website. Thank you very much for inviting me. It's been a pleasure to be with you. And I hope to, I'm sorry we couldn't be in person. Hopefully we cross paths again soon.
Professor Waldman, thank you for your time to give a talk in this forum. Doctora Vega, le devuelvo la palabra.
Muchísimas gracias, Ariel. Muchísimas gracias, Ari. Realmente muy interesante que nos compartan justamente toda esta investigación que está realizando Ari en relación a estas compañías, cómo están concibiendo ellos lo que es la protección de derechos y bueno, pues cómo nosotros debemos de protegernos de cómo ellos lo conciben.
Sí.
Creo que es algo muy, muy interesante. Sin duda alguna, ya me anoté el libro, lo voy a solicitar para que lo podamos tener en la biblioteca, leerlo y por supuesto establecer un diálogo con Ari y también con todos nuestros asociados. Quiero decirles que tenemos visitas, bueno, pues desde igual, ¿no? Nos visitan desde América Latina, varios lugares. Tenemos gente pues de Panamá, tenemos gente también aquí de Puebla, Querétaro, también de Morelia, de la Ciudad de México, del Estado de México. Es decir, como ustedes saben, este webinario va a llegar a una gran cantidad de personas y también será escuchado por una gran cantidad de asociados y amigos del AMBAC. Entonces, pues les agradezco muchísimo a ambos esta interesante charla y pues no me resta más que darles el agradecimiento de parte del AMBAC y entregarles de manera virtual sus reconocimientos. Héctor, si eres tan amable de colocarnos sus reconocimientos. Well, in the first time, la Asociación Mexicana de Bibliotecarios entrega la presente constancia al doctor Ari Ezra Waldman por su participación como ponente del webinario La privacidad de los datos personales de los usuarios de bibliotecas y centros de información este 25 de octubre del 2021 y firma nuestra presidenta, la doctora Brenda Cabral Vargas. Queremos darle las gracias a Cambridge University, además, por haber traído tan excelente ponente. Mil gracias. Sin duda alguna nos abre muchas puertas y puntos de reflexión. Muchas gracias, Ari. También la asociación... you have comments? Ok. También la Asociación Mexicana de Bibliotecarios entrega la constancia. Héctor, ¿podemos verlo? A nuestro moderador, al doctor Antonio Morán Reyes, a quien le agradecemos que haya estado con nosotros este mismo 25, compartiendo con nosotros esta moderación. Mil gracias. Me confunde. Antonio, te quiero decir Ariel, pero Arbón, ya me confundo. Antonio, mil gracias, doctor Morán. Bueno, pues entonces, sin más, pues vamos a pasar a un anuncio de parte de nuestro patrocinador de Cambridge University. Los esperamos con el siguiente webinario y por favor no dejen de estar con nosotros. Tenemos muchos más temas e iniciativas que compartir con ustedes de parte de tanto de nosotros como de nuestras empresas amigas. Muchas gracias, nos seguimos viendo. Que pasen una linda tarde. Hasta luego. Estimados asociados, tuvimos un...
Cambridge Open Access, una iniciativa de la editorial de la Universidad de Cambridge, sirve a los autores, las bibliotecas y la comunidad académica a través de la publicación de contenido de acceso abierto de alta calidad y revisado por pares para que los lectores puedan redistribuir, reusar y adaptar el contenido en nuevas formas. Nuestras iniciativas permiten que los autores cumplan con los mandatos institucionales, publicando en acceso abierto bajo modelos sostenibles. A través de nuestras iniciativas de Read and Publish, hemos logrado que más de 900 instituciones alrededor del planeta puedan publicar sus artículos y libros en acceso abierto. Y estamos trabajando para sumar más instituciones en diversas regiones geográficas a iniciativas como Read and Publish, Open Engage y nuestras políticas de archivo verde. Deseamos acelerar la capacidad de la investigación académica para resolver problemas complejos y beneficiar a la sociedad. Esperamos que pueda unirse a nosotros en esta iniciativa. Descubra más en cambridge.org/Open Research. Cambridge Open Access, una iniciativa de la editorial de la Universidad de Cambridge, sirve a los autores,
Estimados asociados, tenemos unos problemas con la transmisión, como pueden darse cuenta. No se preocupen por sus constancias, vamos a tomarlas directamente del chat para que ustedes tengan su constancia de participación y se las hagamos llegar. Le pedimos una disculpa a nuestra empresa amiga por estos problemas que nos sobrepasan. Estamos tratando de restablecer la conexión, pero parece ser que no podemos pasar por completo el video. De todos modos, en la edición final del video vamos a colocar la cintilla completa de Cambridge University, quien nos ha hecho el favor de estar con nosotros el día de hoy. Pues muchísimas gracias y nos estamos viendo.